We're still in part one. Any comments on part one? Honorable Bulanova, you have the floor.
Speaker, sir, on clause 5, just a point of clarification, sir. 1A and B. A sex offender is a person who has been convicted of sexual offense, or B is a corresponding sex offender who resides in Fiji or enters Fiji with the intention to reside in Fiji. What about the tourist, and commits an offense here? Just a point of clarification here, sir. Thank you.
You're just asking a question.
For clarification, sir.
Okay.
About the tourism who comes in Fiji and commits an offense, the sexual, what do you call this? Sex offender. Does it cover him or not? It doesn't seem to.
We'll take that. Is there any further? Honorable.
Sir, if a tourist or Fijian commits a sex offense in Fiji, will get charged by the police.
Yes.
The matter gets reported. If they're tourists, they come here for 5 days, they commit a sexual offense, the matter gets reported, he or she gets charged. And they go before the courts.
He's asking, no, the question is asking for clarification whether in part 5 there, that sex offender also includes tourists who come to Fiji.
Yeah.
That's his question.
Yes. So, Mr. Speaker, sir, by us having this register, this law is essentially predicated on the Australian and New Zealand system. It will give us an opportunity to be able to share our information with them and them with us. And that's the only way we'll know. So, for example, if a tourist comes in, we could red flag it. It could be on the immigration list, and that could be red flagged. That's how we actually get the data, because we don't know at the moment. There's probably somebody in Sydney who's just been, convicted of a sexual offense. We don't know that. We don't know the name of the person. But if we have our own register and we're able to have some collaboration under the Mutual Assistance of Crime Assistance law that we have, then we'll be able to get their data too. That's the only way we will know.
Thank you.
Correspondingly, sex offender who resides in Fiji, that's a citizen or Fijian, or one who enters in Fiji with the intention to reside in Fiji. That doesn't include a tourist who just come here for 2 days or 3 days and back.
Because the tourist does not reside in Fiji. That's the point. A tourist does not reside in Fiji.
And if he commits?
A person resides in Fiji if they're going to live here.
If he commits?
Can I please complete?
Honourable Member, when you asked your question and Attorney General is answering, just let him answer the thing. Then you can have the floor again if you wish.
Sir, so if a tourist does not reside in Fiji, you may say somebody who works at a high commission, works for an international agency, or gets a work permit in Fiji. Right? So they are now residing in Fiji, and therefore they will also go in the register in Fiji. Okay? Now, if a tourist comes in, we won't know unless the jurisdiction from where the tourist is coming from gives us that information. And this is what I'm saying, you have mutual sharing of information. And then we'll know. If the tourist comes to Fiji and commits an offense, then again, he or she will get charged in Fiji for that offense. And he or she will then serve a prison sentence in Fiji if prosecuted successfully. And then he or she, after they serve their sentence, after they're convicted, will go on our register. They may leave for their home country after that, but they shall be on our register. I hope that explains.
Thank you. Honourable Wanganika. Tanya Wanganika, you have the floor.
Microphone.
Mr. Chair, well, this is section 518, the definition of sex offense. We've had situations in court where two teenagers, both 15, are consenting for a sexual offense. And in most cases, the parents report the boy, and it's only when they go to court then they do realize that the teens have consented. Then what happens? The court discharges without conviction, or there's a bound over. Now, my understanding of this bill, if anything, is to protect the child. In essence, protects the child from pedophiles. So in this kind of situation where it's one of the reputation of the teenage young man, he'll fall into this definition. But also, a teenage girl as well can also fall into the definition. So just a question, Honourable Chair, to the Honourable AG, how are we be treating this? Because it's quite wide, where we've had situations in court where two consenting teenagers are trapped under this definition. Thank you, Chair.
Anyone else wishing to take the floor? Honourable Attorney General.
Thank you, sir. Mr. Chair, sir, if you look at the definition of sexual offence, and I've got the laws here, and I refer the honourable members, it says, means, except for section 213, an offence under part 12B of the Crimes Act 2009. Now, what are the offences under part 12B? Offence of rape, attempt to commit rape, assault with intent to commit rape, sexual assaults, abduction of children of a person under 18 years of age with intent to have carnal knowledge, indecent assault. The only one under this section that does not fall under the definition of sexual offence is indecently insulting or annoying a person. There's the offence, you swear at somebody, for example, it says, a person commits a summary offence if he or she, intending to insult the modesty of a person, utters any word, makes any sound or gesture, exhibits any object, intending that such word or sound shall be heard or such gesture or object shall be seen by the other person. So that does not fall under the definition of sexual offence. Defilement of children under 13 years of age in this particular part, yes, that is a sexual offence. Defilement of a young person between 13 and 16 years of age, yes, that is an offence. Defilement of intellectually impaired person, yes, that is an offence. Procuration for unlawful purposes, procuring defilement by threats or fraud, administering drugs. Householder permitting defilement of a child on premises. Householder permitting defilement of a person under the 16 years of age on premises. Conspiracy to defile. Unnatural offences with animals. Incest by any relative. Knowledge of age is immaterial, it says. So that's part 12B. All of those offences fall under the definition of sexual offence, except as it says, 213, which is indecently insulting or annoying modesty of a person. So that's the definition.
Thank you. Thank you, Honourable Nikanawai.
Honourable Chairman, I go back to my question. I've seen the definition is very, very wide. The only exception is if you there's only one exception is indecently insulting. So even what we can categorically call minor sexual offences are, and the question is, on 7, clarification, I go back, appears to me to say that whenever you commit any of those offences, you are registered as opposed to repeat offenders and serial offenders. So could you just clarify, under this, it means that any sexual offence, and even if you're committing it for the first time, you'll be registered, so that the public should know, they're entitled to know that, if that is the case.
I can confirm, sir, that is the case. The public does not know. The public may know already when you go to court. Already people can go for crimes, the media will report it.
Well, I mean,
But after that, once you get convicted, the register is there for certain agencies to access, not all and sundry. You and I can't go and access it. It's only those agencies where these people could be employed, where they may have a proclivity to make use of those people, or they could be their potential victims. That's the only area. That's why it's specified clearly. And that's why also the Commissioner of Police will issue more further guidelines about protecting. So it's not like, for example, Ministry of Education, they'll give it to anybody in Ministry of Education. There would be one person with access with their PIN number to be able to access. It probably is the Permanent Secretary for Education. There would be one person from one agency to access that. And we will know if that information is leaked from that agency, we'll know exactly who leaked it. Because we have to, and I know what Honorable Nawekula is on about, and I agree with him in that respect, that we have to also protect the privacy of that individual. So, assuming that if I am convicted under one of these offences, and I never go and work for any of these agencies, assuming I go and start driving a truck in the middle of the bush, and that's what I do, nobody will need to search my name. I may be reformed. So let it be. And I'm not coming in contact with children or other vulnerable people. I may be, I may have gone somewhere and I'm just, set up a fish farm and I'm doing my own thing. Nobody needs to know. Somebody may want to do a search on you if they want to, through a PC, but certainly not through this register. Only authorized people will be able to access this register. So we are saying, wherever there's a vulnerability, the Ministry of Education for now should do a check. Daycare centers should do a check. And the Commissioner of Police will say, those who want access to this information, he may actually say, you simply give me the name and I can tell you, yes or no. He does not have to give them access to the entire register. That's how we balance, we protect our children, but we also protect the privacy of the individual who has committed a crime.
Thank you. Honourable Linda Tabuya, you have the floor.
Thank you, Honourable Chair. Just on the same section 5, just again also probably a point of clarification. As far as the example that was given about defilement being included, defilement of a person between the age of 13 and 16 being included in the definition of sexual offence. The example given where there are two children or 13-year-olds, for example, that engage in experimental sex. It's usually when they get caught that parents report them. Of course, this is where two are involved. The practice has been, and we've seen where the boy is charged and the girl becomes the victim. Now, in this case, Honourable Chair, if you have children involved, if we're trying to protect children, and we are looking at balancing the rights of these children, then perhaps the rule to apply that the definition of a sex offender be someone that is, for us to consider the protection of these children as they're still in their growing years, and that they will have to face, being charged, they'll have to face the crime and coming to juvenile court. But if it's to go on a register and we're wishing to protect children, then can we consider the definition of the sex offender to be a person 17 years and over to go on the register? Because if they've committed a crime at that age and they're convicted, does it mean they also go on the register, and how long does it last for that child? Again, balancing the rights, if that could be for 17 years and over, because that's the age and a juvenile can be treated as an adult and tried as an adult. So just a point of clarification, if that can be clarified, please. Thank you.
Honourable Attorney General.
So the register will obviously also have the offence. it won't just say sexual offender, what the person was convicted under. So if you generally, of course, and many parents would know that if you have teenage children and if they go off, and as Honorable Tambuya says, experimental sex, and if they engage in sexual activity or carnal knowledge of each other, as it's called, they may go off and do that, but nobody reports it. A lot of kids are doing that at the moment. Now, in some instances, you may have a parent that may find out about it and then report the matter. It is an offense. And the person will get charged. And it will go on that person's record. Now, we have to then go back and think, what are we trying to do? Why are these laws there in the first place? What's the philosophy behind it? On one hand, we complain about teenage pregnancy. We talk about how teenagers are getting... I mean, I got a phone call last night from somebody who's a teenager who's become pregnant, wanting assistance. Now, what were the parents doing about it? What kind of values are we teaching them? That also goes back to it. Philosophically, if you want to remove this, then you could have, these very hormonal teenagers going around and having sex. There has to be a deterrence about it too. And as we know, it's not very healthy, in particular for young girls. They fall pregnant, they get left behind in school, so a lot of them stop going to school. There's in fact a program to try and get single girls to actually go back to school who've actually fallen pregnant. So it's a wider philosophical issue. Now, there are also children, what we consider children under the UN definition of a child. A person is a child until they reach the age of 18. They are 17-year-olds who've actually raped older men and women, younger children than them. So are you saying that nobody below the age of 18 should be charged or should not show in their records? So I think we have to understand why we have these laws in place. We don't want these teenagers to go and have sex. And a lot of parents, of course, now allow them to have sex. They said, as long as you don't fall pregnant. You may recall a few years ago when USP, these are kids over the age of 18, put a condom machine at the university. A lot of people objected to it, saying you're encouraging them to have sex. Some people argued and said, well, they are having sex, so why not put the condom there? It's a horse and the cart situation. Honorable Prasad would know about this. He was at the university then as a lecturer, I'm saying not as a student. So I have to admit, Mr. Chair, sir, when I said yesterday Honorable Linda Prasad, he kind of blushed. But getting back to the serious point, sir, that's what we have to understand. We have to be able to understand what's the philosophy behind this. And like I said, so for example, if a person, assuming two consenting teenagers have sex, and one of the parents reports it, and the person subsequently gets convicted, as you know, you need conviction if the supposed victim also gives evidence. And as we found in a number of cases where there are two consenting teenagers have had sex, and if one, generally is the female parents that gets aggrieved and say, let's take this boy to court. Now, and then the girl may refuse to go to court to give evidence. A lot of these cases fall by the wayside as a result of that because they've consented to it. So it does not proceed any further. But assuming it does, and the person does get convicted, it will say for what offense. So later on in life, we know that this person's been convicted because of two consenting teenagers having sex. Not because they went in, had sex with somebody without consent, which is rape. Or, as you know, that under this provision also, we have a lot of cases of defilement by older men. Some 24-year-old who entices some young girl who's 16 or 15 with a nice mobile phone and, in his nice flash car. That's what happens. So there is an offense too, because these people are vulnerable. So that's why we have these provisions there.
Thank you. Honorable Anjali Tiamdiani Barabi, you have the floor.
Thank you, Honorable Chair. I seek clarification on clause 5.2, which currently reads, a person ceases to be a sex offender if the conviction is in respect of a sexual offense or corresponding offenses that qualifies a person as a sex offender is quashed or set aside by the court of law. My issue, Mr. Chair, sir, is what consideration, if any, can be given to those that have been convicted for sexual offenses but have been rehabilitated and living a normal life, say 10, 15 years. How can their names be removed from the register of sex offenders? That's my question, sir.
Thank you. Honorable Attorney General, you have the floor.
So the reality of the matter is that we have these provisions in place to give protection to people. And of course, as time goes on, we can always come back to the law and look at it. This is the first time such a law is being put in place. There are various regulations that have been put in place. This is, like all of you have acknowledged, a new area of the law for us. We have to address this. Honorable Randrondro has spoken on numerous occasions about the rise in sexual offenses in Fiji. We have to take proactive steps. It's also about having a registry process, giving people access to their information to make sure they don't re-offend or put them in an environment where they may get tempted to offend. It's also about addressing it through community awareness, family values, all those combined. It's a holistic approach to try and address this issue of the rise in sexual offenses. So this is part of one of the mechanisms through which we can address this issue. We can always come back and look at how this pans out. Whether we want to, in fact, make it a lot more stringent, make it a lot more lenient, as we've seen in other countries. They have, the law has evolved with the times, depending how community standards view it. We have certain countries where 3 strikes and you're out. There's various mechanisms that you can look at. So at this point in time, this is how the law stands, and obviously we can always come back and look at it in a few years' time. Thank you, sir.
Thank you. Honorable Tanya Wanganeka, you have the floor.
My apologies, Chair. There's no question from me. There was an error in my pressing. My apologies.
Thank you. Honorable Linda Tambo, you have the floor.
Thank you. Just another quick question from what the Honourable Attorney General has explained. In terms of the expunging of records, when offenders after 10 years have their records expunged, will the same apply for the sexual offence register? That it will be expunged after 10 years?
Thank you. Honorable Attorney General.
At this point in time, sir, the register is is separate to the PC list, previous convictions list. It's a separate register. It's not part of the quashing of that. So it continues in the register, right? It continues in the register. Because we've seen people who have a proclivity for doing this. So, you could, for example, a lot of people, when they apply for certain things, and after 10, 15 years, when you do a search, it's not there, right? It's not there. So, for example, if I did, say, larceny, and then also raped somebody in the process of the larceny, or robbed, we've seen many cases where robberies have gone wrong, and a person also ends up, or group of people end up raping the householder. Now, after 10 years, your robbery violence may go away, but your sexual offender provision is still there. Because if we really want to be serious about sexual offences, we have to address it seriously.
So if there is the issue of proclivity, as you mentioned, Honourable Attorney General, then would it then make sense for what has been submitted from opposition that there be a consideration of perhaps a repeat offence, like they have in overseas jurisdictions after 2 offences, then you go on the register, so that first offenders, though they're convicted and they may be go away for, they might have their conviction discharged without conviction, like juveniles are given, or other sentences that are, bound over or whatever it is, that this be considered for a repeat offender to go on the register after 2 offenses and more? Now that you're considering that this will be pretty much in the register for life, balancing the rights of the sex offender, the individual. Thank you.
So again, I'm a bit concerned about what Honorable Tambuya is saying. On one hand, they've been talking about the impact of pornography, about the increase in sexual offenses. Now they're saying that even if you can only put a person on the register if they've committed sexual offenses more than once. So the first time they've done it, even though they may have violently raped somebody or a young child, young boy, we don't put them on. That's what you're saying, essentially. You're saying that if I do it again, or 3 times, then only, you said third strike out. Only after the 3rd time I've done it to somebody, then my name goes on the register. I think, well, what is the severity? Let's get into the space. That is not a sexual offense. Read the section. Read the section. It does not say that if you touch somebody, you commit a sexual offense. Read the section.
You've mentioned if someone touches someone's, back or behind, if it's a woman, she may take offense to it and see it as a sexual assault. That's touching. That to her is sexual.
Please.
Yes, sexual harassment policy.
Sexual
harassment policy, that's a sexual assault. That is a sexual assault.
No. Sir,
when you touch someone, it's an assault. Just to clarify.
All right. You asked for clarification. Honorable Attorney General will clarify. You have.
Honorable Tambuya is digging herself into a hole. Let me just read this again. Offense of a rape, attempt to commit rape, assault with intent to commit rape, sexual assault, Mr. Speaker, sir, and it says a person commits an indictable offense, not summary offense, indictable offense, which is triable if he or she unlawfully and indecently assaults another person or procures another person without the person's consent to commit an act of gross indecency or to witness an act of gross indecency by the person or any other person. Gross indecency. Honorable Tambuya, you would know as your days as a prosecutor that the courts have developed the jurisprudence around this. One of the problems we have at the moment, what a lot of females are complaining, is sexual harassment is not specifically captured here. If I go and touch somebody on the back, it's not gross indecency. You know that as a lawyer. If I touch a female on the back, it's not gross indecency. Even we've had complaints about people who've tapped, a female's bottom. Under this definition, it does not fall as gross indecency. And that's one of the lacunas in the law at the moment. We've recently had a case about some executives inviting people to come and have their employees dinners, sending them nude photographs of themselves. Right? You know who I'm talking about. You did not come to the protection of that lady. But the fact of the matter is that there's a lacuna in the law. We need to be able to address that. There needs to be specific jurisprudence regarding sexual harassment per se. But under the definition of 12B, that does not fit in here. Under definition of 12B, these are the ones that I've just read out, except indecently insulting or annoying a person, and a person commits that summary offense if they utter any word, makes any sound or gesture, exhibits any object, intending that such a word or sound shall be heard, or that such gesture or object shall be seen by the other person, or intrudes upon the privacy of another person by doing an act of a nature likely to offend his or her modesty. If I go and pee in front of somebody, for example, the person seeing me peeing may get offended. I may affect their modesty, but it does not fall under the definition of a sexual offender. That's the point. All the others, defilement, abduction, sexual assault, rape, defilement of intellectually handicapped persons, procuring defilement by threats of fraud administering, householder permitting defilement of a child on premises, conspiracy to defile, unnatural offense with animal, incest by a relative. These are very serious offenses. They're not touching somebody's back.
Thank you. Before Jaragib, Honorable Linda Tambua, and then Honorable Biman Prasad. Honorable Linda Tambua.
Gerengere Tambua, sir.
Honorable Gerengere Tambua.
Thank you. Thank you, sir. So my question is in regards section 5.2, where a person ceases to be a sex offender if the conviction in respect of the sexual offence or corresponding offence that qualifies the person as a sex offender is quashed or set aside by a court of law. I would just like clarification on how you go about having that set aside by a court of law. Thank you.
So if, for example, a person gets convicted by the High Court for rape, and then the person is sentenced, and a person is convicted, sentenced, and goes to prison. Then the person's name goes on the register. In the meantime, once I'm in prison, I may actually appeal the decision. So I go to the Court of Appeal. If the Court of Appeal finds that actually I did not commit the rape, then that quashes the conviction, then my name is removed from the register. You have to go through the appeal process in the court system.
Thank you. Honorable Biman Prasad, Professor Biman Prasad.
Yeah, thank you. Just wanted to make a general comment, and if that can help us to move on. I think the Committee on Law and Justice, Law and Human Rights did a very good job. They produced a very good report. They've looked at research in other jurisdictions. And I think they do acknowledge, and everyone acknowledges that this is a new law. And I think it's a good law, it's a good beginning, and we actually support this law. Normally when you have a new law, it takes time for the law itself to take its course, create a new data set, and a better understanding of the actual impact it might have on different issues that I think has been raised by honourable members this side. And I think the committee also makes a good recommendation, 1 and 2. One, of course, is about the advocacy program, getting people to understand this law, the implications of this law. We might have done that through the committee, but I think the committee's recommendation that more of that is done makes sense. And the second recommendation is also a good recommendation in the sense that it says that at some point in time, 3 years or 4 years or 5 years, this law can be reviewed. We might have more data then. We might have understood better, the implications of this law. So I think we need to take that into account, and I therefore think that this is a good law, a good beginning, and we support it. Thank you.
Thank you.
So could I just make one last comment, sir?
Honorable Attorney General, you have the floor.
This law also highlights the point I was making yesterday, how it is critically important to get the person's registered name right. Because if you don't have the right name, because we have found, for example, there are people who have been convicted under their alias name through the criminal justice system. And they have gone under alias name, and then when the supervisor of elections wants to check the roll against people who are in prison so they can't vote, names don't match. So this is why if we are developing such a register, and you can imagine the impact. If you get the wrong name in the register, your name's there. That's why the authentication of your identification is critically important, resting on one source of identity, which is the birth certificate. So it's critically important. So I just wanted to highlight that because, I mean, I can understand people, thinking, well, the name is going to be there for the rest of the life, or it will affect your employment opportunities. And that has happened in overseas. We've seen in USA, identity theft is a big thing. Whether for the issues of social welfare payments, ration distribution, convictions, and some people have unfortunately fought for decades to get their names off lists because they had the wrong name. So I please urge the members to take that into account too. One last point I want to make, sir, is about the issue about pornography. So I wish that the honorable members would also be equally as zealous about the hate through communal division that's actually spread through websites and Facebook. We have seen, Mr. Speaker, sir, that there is also what we call the dark web. You shut down sites, they'll put up another one. There is a whole cabal of people who don't access what we call mainstream internet. They have dark web. You set up the VPNs, I think it's called. They set up the VPN, they can close it overnight, tomorrow they'll open another one. You shut that one down, they'll open another one. So it's not just about shutting sites down. It's also about ensuring that through these mechanisms, in developing community values through your families, that we tell our children it's not a good thing to access. Thank you, sir.
Thank you. Honorable members, thank you for your contributions. We will move on. The Parliament will now vote on Part 1. The question is that Part 1 stands as part of the bill. Does any member oppose the motion? As no member opposes, the part is agreed to unanimously. Secretary General.
Part 2, Division 1.
Honorable members, the floor is now open for comments on Part 2, Division 1. Honorable Vitialim Buddha, you have the floor.
As I move, sir, to delete this establishment of this register, because it allows registration of sex offender for life. That's what I oppose. You need to give them time to change for a better person. Thank you, Lord.
Is there a seconder? If you, Honorable Vitialim Buddha, if there's no seconder, we can't.
I second the motion, Mr. Speaker.
Oh, your honorable offsider.
Huh? No? What?
Yeah. Honorable
Yes.
Bulldozer.
Yeah, thank you.
You have the floor now. To speak to your motion.
Thank you, Speaker. Chairman. The approach here in this bill, Honorable Speaker, sir, that I do not support. It is founded on hate. You're hating the person. You should hate the evil that is in that person. And the bill is founded on to condemn a person when he's sex offender. So it is important, Honorable Speaker, Chairman, sir, to ensure that our laws are based on biblical values and principles. It's very important to give opportunity to any offender for change. Time to change. Time to change. When you change, you should take his name off that register. So it is important, Honorable Speaker, Chairman, sir. You don't put his name on the register until for life. Even when he dies, his name is still there. And the stigma goes with the family. See? If you just give them 5 years or 10 years or 15 years or up to that, and he changes in between that, fine. Take his or her name, her too, or her, not only him, her too, off the register. So it is important, Honorable Speaker, sir, to set our laws on biblical values and principles. You see the spirit of that person in him. When he changes, we should allow him to change them. Take his name off the register. It is important. It is too stringent, the law, Honorable Speaker, sir. The register in the police is enough. The register in the court system is enough. Why have another national register? It's already there. It's already monitored in the police and the judiciary. It's already there, Honorable Chairman, sir. All you can do is increase penalties. Until time he has changes, fine. Forget his sins. Forget what he has offended. He has changed, Honorable Speaker, sir. Law is good, but it must have a spirit, a good spirit, a spirit of love, a spirit to build people up, not to condemn, not to kill. That's why the 10 Commandments are there. That's the Holy Spirit, the spirit that should go with the law. Not human or manly law that condemns a person.
Of misinterpreting.
That kills a person, Honorable Chairman, sir. So it is important. And the Lord Christ came to confirm the law, but with the Holy Spirit. You know, the law that we create or establish must have the Spirit with it. Must be the Holy Spirit. Otherwise, you will have the evil spirit, Honorable Spirit. And I'm afraid we're having that here. It is, Honorable Speaker. It's very important, Honorable Speaker, sir.
Honorable Member, you started to repeat.
The spirit of the law must be there. Teachers Christ teachers has taught us that we must have love and teach and monitor and guide the people in their life, Honorable Chairman, sir. We are all sinners, yes, we are all sinners. We are all sinners. But we need to confess. We must be given time to change. Even the Lord Jesus gave, through his blood, forgives our sins. He is the Creator. And we were made to be in his image and his likeness. We should also forgive when somebody changes from bad to worse or from bad to better or good. So it is important, Chairman, sir, that we must follow what Jesus has said, because we are made in his image and in his likeness. When an offender is changed, we must forget him. Take his name away from the register. It is important, Honorable Speaker, Honorable the Chairman, sir. We have right, yes, we have individual right. Individual right is more important because your individual right will take you to eternity. Not community right, even though we respect community right. It is important, Honorable the Chairman, sir. But we also must watch on what leads people to sex offenders, like it's already been mentioned. Pornography, dance bars, and all and so on and so forth, and the technology that we have here. So these are all symptoms, Honorable Speaker, sir. We should go to the problem. What is causing all this problem? So it's important, Honorable Speaker, sir, not to only try to write the symptoms here. We must go back to the family. We must build up a good family here in Fiji to bring up good people in the future, not to offend sexual offense.
You're starting to repeat yourself.
That is important, Honorable Speaker, sir, Chairman, sir, that the intent of the bill should be correct. Because there are yellow ribbons there, already there. Also the religious organizations there, who can build those people up. There are also the Bonua there, it's already been mentioned, who can build those people up. And various groups there, who can build those people up to be a better person, rather than condemn him for life under register. We must not condemn the person. We must penalize the sin, it's all of that, but don't condemn the person, Chairman, sir. So it is important. We don't follow what the Americans do. Don't follow them. We do what we do according to our Bible, according to our values. It is important, Honorable Speaker, sir, that the mechanism is there to create opportunities for people to become better. Thank you, sir.
Get on with it. Get on. Honorable Rasova, you have the floor before I give it to Honorable Gerengera Tambua. How come you're playing the knight in shiny armor all of a sudden? I'll give the floor to Honorable Gerengera Tambua.
Thank you, Honourable Chair. I just want to take this opportunity, while Honourable Bulanotha may have his point of view, and some of us are laughing at him, some of us are laughing with him. I just want all honourable members to remember that the people of Fiji are watching us, and to hear people laughing while we're discussing this very serious matter is very unparliamentary. Thank you.
Does repentance come from within, not from outside?
Honorable Attorney General, you have the floor.
Mr. Speaker, sir, it's very interesting how NFP always obfuscates matters. They don't have the courage to say anything against what Sodelpa says. Even though they may disagree with it, it's very interesting how Honorable Gerengera Tambua just twisted the whole thing and saying, we are laughing at it and the people of Fiji are watching. What would have been more useful from her is to tell us whether she agrees with Honorable Bulanotha or not. Yeah. She didn't have the courage to say that. And people are watching her. And the other female members from the other side too. I saw when Honorable Bulanotha made that intervention, Honorable Linda Tambua signaling to somebody to there to second it. When just a few minutes ago, the leader of opposition did not object to this, but he in fact wanted Ministry of Itauke Affairs to be involved in the list of the agencies. The leader of Sodelpa also agreed, and he also wanted them to be in the list. Then we have Mr. Speaker. There's no point of order. Mr. Speaker, sir, again, Mr. Speaker, sir, then you have Honorable Bulanotha saying he doesn't want this register. That's the whole purpose of this act. That's the entire purpose of this act. So he does not want this act. He said to get, so it is not functional. So the opposition needs to tell us what is their position. If they have made individual submissions, well and fine, Mr. Speaker, sir. So please, Mr. Speaker, sir, this is a serious matter. Mr. Speaker, sir, we have said, both sides of Parliament have agreed that the rise in sexual offences need to be curtailed dramatically. We need to have community awareness about it. We need to ensure that the patriarchal notions, and most people who are victims of sexual offences are females. That is a fact. And we have to ensure that these patriarchal notions of how we view women as sexual objects and how we see them as second-class citizens, all of that is part and parcel of this building up of a colossal of laws and practices to ensure that this stops, if we are really serious about it. So Honorable Bulanotha has said this, essentially, and saying that he's not for this. Mr. Speaker, sir, my challenge is that to the NGOs and the women's groups that are listening to this, I hope they also have the courage to come out and condemn what Honorable Bulla Nauda has done, has said. I can bet you, now that I'm saying they may do it, they won't have the courage to do so. Mr. Speaker, sir, these things have been done and adopted by many jurisdictions, including in Australia and New Zealand, as a mechanism to deter people from engaging in these offences. It's a deterrence mechanism that you think twice, you think 5 times, that if you commit this offence, you get convicted, your name will go in a register. That is one of the purposes for this. We amended, we in fact repealed the penal code, the old penal code more than 100 years old, and brought in the Crimes Act, where, Mr. Speaker, sir, we enlarged the scope of sexual offences. We increased the terms available for conviction, again, as a mechanism to stop people from engaging in this act. Mr. Speaker, sir, the reality of the matter is, and I think what really is quite offensive, and I find from Honorable Bulla Nauda, that he wants to, when it suits him, speak about love, about humanity, loving the spirit. He in 2000, and I've said in Parliament before, stood up, he's saying gone. 2000, outside Civic Centre, in the documentary, available at USP, stood there and said the executive is run by Kendya Hindu Tevoro. Judiciary, Kendya Hindu Tevoro. Is that love?
So sad.
Is that love? Is that about humanity? Is that spreading the love of Jesus Christ? Is that spreading the love of Jesus Christ? That's utterly hypocritical. And time and time again, on the floor of this Parliament, Honorable Bulla Nauda is been the main people behind the racial and ethnic categorization of our people. Is that the love of Jesus Christ? Jews and Gentiles alike. Didn't he say that? Jews and Gentiles alike. You are bound by a love of Jesus Christ irrespective of your ethnicity. Exactly, but you're not practicing it. He only says it when it suits him. And this is the level of hypocrisy that exists, Mr. Speaker, sir. So, Mr. Speaker, sir, I get back again to the point, and the point is that this act is to ensure that we have a shield of deterrence mechanisms in our laws that these people don't commit the offence. If somebody is thinking of committing an offence, that they think twice, 3 times, 4 times. They don't see some vulnerable kid who's walking down the street in a cinema or going to the farm that they can do whatever they like with them. They need to know that. And the way that they know that is that when you review the laws, you have registers. Other countries have adopted this. Again, because of the objectification of children, objectification of women. And we need to make a concerted effort. Thank you, sir.
Okay. Honorable Teododo, you have the floor.
Yeah, thank you, Chair. I just want to make this contribution in light of what the Attorney General has pointed out with regards to Honorable Ngarangara Tambo in the NFP. Our position is defined, it's clear, it's just been uttered by the Honorable Biman Prasad. We support this bill. Now, what the Honorable Ngarangara Tambo said is this is a serious bill that we are considering. Different people look at these bills from different perspectives. It does not augur well that we are laughing over these issues when it is not a laughable matter. That's all she said. Now, I'm just saying here, Honourable Speaker, that that comment made by the Attorney General in terms of NFP's position on this matter is not true, and it's not, it does not reflect our position. We have a position on the bill, and that has already been uttered. People have their own comments. So, you know, there's no need to bring, you know, persecution of religion or comments on different teachings and all that.
Why is he bring that religion thing?
Yeah, well, exactly. This is the point I'm trying to make. We, it's not a laughing matter at all. And that's the position. Our position is defined. It's already, because the AG is saying, is questioning Honorable Garangir Tambua's comment to, position on what Honorable Mitimbulo is saying. We have a position as the party, and that's already been conveyed, and that's where it is. So, seriously, Honorable Speaker, we should not be laughing.
Honorable, I'll give the floor now to the right of reply. You have the floor for your right. Honorable, right. One more speaker before the right of reply. Honorable Biman Prasad, you have the floor.
Thank you, Mr. Speaker. It's very usual of the Honorable Attorney General. He's actually got a habit of bringing NFP. He knows very well that we have disagreed with Honorable Bolanuda on many occasions, publicly in this Parliament. And for him, I know why he's saying that. I know why he's saying that. He heard what I said about the bill, our position on the bill, we support the bill, and he had to pick on NFP to say, we're sitting here and don't say anything what Sodelpa says. We don't agree with everything that every member from the opposition says about things. Sometimes we don't have the opportunity straight away. But for him to go on and on and on, he's actually, playing to the gallery. No, it's a point. Because he is trying to insinuate, we don't take a position. Let's be honest. I think you need to be a bit more honest, Honorable Attorney General, about, how you say that. And accept that we do have a position on many things. So I just wanted to remind him that, Mr. Speaker.
Before I give the right of reply to Honorable Ngalwoka, I'll let you take the floor.
Thank you, Honorable Chair. Let me just correct what has been said about Sodelpa. What I outlined from the beginning was that this is, for us, a vote of conscience. We had this kind of dialogue before we came. And if you look at, because we are aware of the difficulty with which people have expressed their opinion, or the thoughts, the way things are in Fiji in relation to this. And I'm sure the members of the committee can testify to the fact that there are people who express opinions similar to what Honorable Bulnode is saying today. And if you look at the recommendations of the committee, they are very cautious in the way they're recommending this. Let me just read. On one, they say the projected impact it will have on people is too great and should be something that all Fijians are given appropriate awareness on. So when he expresses that, Sodelpa is aware of this. That is why we came here today saying we will vote on conscience. We cannot have a party position on this. And they go on to say, the bill is new, and this review will have to be carried out after an adequate period has passed, preferably a period of no less than 5 years. So there's a lot of caution in the way the committee has made the recommendation. So please, don't just say that Sodelpa has no position on this, that Sodelpa is not aware of the challenges that we face. We are aware of it, but we know that this is a new bill, a new phenomenon with us, and we allow our people to speak their mind here today. And I just wish that other parties in this country can also do similarly, encourage their people to speak outside of what is being dictated to them. This is Sodelpa. We allow people to have their say on matters that we know they are not comfortable with. And like I said, I'm sure the chair of the committee or the committee members will say that these are the kind of opinions that were expressed during the hearing across the country. So please, don't just dismiss Sodelpa as not being responsible in the way we handle these things. We are very responsible, but we respect the opinion of people on this very delicate matter. Thank you, Honorable Chair.
Thank you. Honorable Bulnota, you have your
Thank you, Chair.
floor for your right of reply.
Yeah, thank you, Chair. Just to clarify that we vote on consent for Delpa on this matter. And I've stated my position, particularly with the life registration on the register. That's my point. If you give up to 10 or 15 years for that person to change, why keep his name in the register? Take his name out from there. It is important because that we teach, we lead people to change. If people change, why should we keep their name in the register? That's my point. Even Christ Jesus cleans our sins. We should be following that, Honorable Speaker, sir. Chairman, sir. It is important. You can increase it up to 10 to 15 years. If the person changes, take his name out of the register. Thank you, sir.
Honorable members, we will now vote on that motion that we delete clause 6. Honorable members, we will vote by acclamation. Those in favor say aye. Aye. Those against say nay. Nay. The nays have it. Honorable members, now vote on part. Are there any more members, honorable members wishing to take the floor on this? Honorable Kurindrani, you have the floor.
Thank you, Mr. Chairman. Just a matter of clarification. Does this register also include the current offenders that are currently serving their sentence when this bill will come into effect?
They seem to be talking.
Right. Honorable Attorney General.
Sorry, Mr.
Does this register will also include those who are currently serving sentences as sex offenders?
Yes, sir. It will include those people who are sexual offenders, yes.
Those who are currently?
Yes. Yes. Yes, sir.
The
yes, sir. Yes.
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 Honorable Ronrondo, you have the floor.
Yeah, thank you, Chair. Just a matter of clarification on section 6(2), the register. I think the importance of the register is to be properly maintained and updated. On section 2, there's an issue on photograph. Say a person who has been entered in the register, how often does that get updated in terms of specifics like photographs and other items that are listed there?
Thank you. Honorable Attorney General, you have the floor.
Sir, the Commissioner of Police, as you know, is in charge of this register. And you see section 27, he develops guidelines in respect of who will access the information. And obviously, in maintaining the register, he has to ensure that the register is up to date. So essentially, the Commissioner of Police has carriage of this register. And he will then authorize people to access it, and obviously has to make sure that the register is most up to date. So, for example, the question asked by Honorable Gerengere Tambua, when does a person's name get off the list? That's his job, to ensure that a person's conviction is quashed, it gets off the list. So things like photographs, etc., needs to be there, of course.
Another clarification, Mr. Chair, on 6.3, which states that the register must not contain information in relation to a person who ceases to be an offender under Section 5.2. The question is, how does a person get his name or removed from this register? Does he apply for his name to be removed from the register, or how does it get removed?
Under 5.2 it says that if you've been convicted, then obviously your name will go on the register.
Yeah.
If the conviction then is quashed or set aside by a court of law, that's when it goes off.
So it's automatically removed by the person?
Not by the... Or who's going to do it?
Yeah,
it's
who's
the
going to remove it from
responsibility
the
of the
register?
Commissioner of Police, because he maintains the register. So then they'll make sure that that person's name gets off the list, because the notification of the conviction or quashing of it will go to the police in relation to sexual offences.
Thank you.
Thank you. There being no further points being raised, honourable members, Parliament will now vote on Part 2, Division 1. The question is that Part 2, Division 1 stands part of the bill. Does any member oppose the motion? As no member opposes, the motion is agreed to, and Part 2, Division 1 stands as part of the bill.